Good afternoon, everyone. I'm Megha Gala, and it's an absolute pleasure to welcome you to In.Talks, the dynamic webinar series by InCorp Global, where we unravel the latest trends and opportunities shaping the business world. Let's kick off with a quick question for you all. What do you think what is common between companies like PhonePe, Grow, and Paperfry? Just think for a moment. Yes, absolutely. They all have recently made the bold move of relocating their headquarters to India. And they are not the alone. Fintech giants like PineLab, Meesho, Flipkart are also considering to be part of this wave. This trend is making waves in India tech ecosystem, and it is called reverse flipping. Now you might be wondering, what exactly is reverse flipping? Reverse flipping essentially means where an Indian startup which had shifted their headquarters overseas and are moving their headquarter or a fundraising platform back to India. This process involves relocation of their assets, operations, intellectual property rights from the foreign location to an entity which is in India. Essentially, it's a journey back home, but with a big business edge. Today, we are diving deep into this phenomenon, which is reverse flipping, startup transitioning to India. We'll cover the key drivers behind this trend, explore its implication, and understand why this shift is gaining the momentum. For this, I'm thrilled to introduce our esteemed panelist, whose expertise will guide us through this conversation. Our first panelist is Kosha Thaker, a partner at Trilegal, one of the leading legal law firms in India, celebrated for its client-focused solution. Kosha has a decade of experience in merger and acquisition, private equity, venture capital, corporate restructuring, and regulatory advisory. Her portfolio spans to sectors like infrastructure, healthcare, real estate, fintech, and many more. Simply to put, Kosha insights would be invaluable today. Welcome, Kosha. Joining her
Good
is
afternoon, everyone. Pleasure to have you here today. I hope the session is really helpful for you. Thanks, Megha, for the introduction.
yeah. So joining her is none other than our CEO and co-founder, Mr. Manish Modi. He's a chartered accountant and a company secretary with 20 years of experience. Money has raised over $2 billion through equity and debt. His strategic leadership has empowered numerous Indian as well as multinational companies to achieve the transformative growth. Welcome, Manish.
Thank you so much, Megha, for the wonderful introduction. I hope it's welcome. Good afternoon to all the participants. I hope that we together are able to help you through understanding this entire process in the next few minutes and take some of your questions. Thank you so much.
Thank you for joining us, Manish. Okay, so before we start, I want to make a quick note. So we want to make this session more engaging as possible. So please feel free to drop your questions in the chat box during the discussion. We'll answer as many questions as we can during the webinar. And for those which we can't, we'll try and follow up through an email. So let's take the stage forward and let's take a brief look into the flipping, the precursor to reverse flipping. And for this, I would like to invite Kosha, who will take us through the concept of flipping and what are the driving trends. Over to you, Kosha.
Thanks, Megha. So now, guys, before we delve into the details of reverse flipping, it's really important to briefly touch upon what is flipping, which is the precursor to this trend. So we understand the context and motivations driving companies to now reverse course. Flipping, as you can see in the slide, you will see it on the next slide when Megha puts it on, is basically refers to the process where a startup, which originally was domiciled in India, transfers its ownership to an overseas jurisdiction by establishing a foreign holding company. In this structure, the Indian entity becomes a wholly owned subsidiary of the foreign company. And while the company might have its operations and primary markets in India, this restructuring positions it to tap into global advantages. Now, there are several reasons why companies chose flipping when they did. And over to you, Manish, to talk about some of the primary reasons for the same, along with examples.
Yes. So one of the most important reasons for flipping maybe a decade back was access to foreign capital. So most of the companies which actually flipped were digital commerce companies, e-commerce companies, fintech companies, about which an understanding of them in the Indian VC ecosystem or the Indian investor community was not that great at a decade back. At that point in time, a lot of capital was available overseas, right? And those pools of capital also were commanding or ready to invest at higher valuations compared to Indian startups at that point in time. And that's why they had to create a reverse flip structure. So, or a flip structure. One of the best examples I can give you is, let's say, for example, Razorpay. It was one of the first companies which was selected by Y Combinator for funding, and as a part of their basic governance structure, they were supposed to incorporate a US based entity. Similar situation was in case of Pine Labs, where they actually created a flip structure to be based out of Singapore so that they were able to raise capital. So one of the key drivers was access to foreign capital, which necessarily also gave higher valuations. Another driver at that point in time was given that e-commerce, fintech was not necessarily restricted to borders of India, but had a market even overseas. Some of these companies also created flip structures for market expansion. One of the best examples I can give you is of Freshworks, right? Which are basically a China-based company which effectively got into the US. Now a Nasdaq listed company, right? So market expansion was another one reason. Then at that point in time, we did not have the entire framework of the legal structure that we have today. So a lot of investors also had a not so favorable ecosystem within India, which meant a very, very strong, robust legal framework and ecosystem outside India in those jurisdictions like Singapore, Cayman, US, etc., where investor protection, certain structures of fixed income securities, etc., were possible to be given in those jurisdictions, which was not possible in India. And necessary to state here that at that point in time, our tax rates were obviously much higher than the tax rate that those were available in, let's say, Singapore, which is at say 17%, UK, which is at 19%, and US. I mean, the corporate central state tax rate was 21%, but the state tax rate was anywhere from 0 to 12%. And with let's say, jurisdiction like Cayman, where there was zero tax. So these favorable regulations and tax rates in those jurisdictions also became a commercial consideration when companies thought of traditional flipping.
To add to a bit what Manish said, is one of the other reasons and driving factors for flipping was that regulatory flexibility also played a very crucial role. Flipping now allows the company way out of restrictions on inflow and outflow of capital under the India's exchange control laws, which can often be quite complex. This includes limitations such as the inability to offer assured returns under the India's NDI regs. Now, relocating to another jurisdiction could mean more flexible and foreign investor-friendly investment structures and attracting a broader range of investors and financing options. I think we're done with reasons for flipping, and Megha, should we now move on, now that you'll have context to what flipping was and why there was so much of flipping in the industry? We'll talk a little bit and introduce you on the concept of reverse flipping, which you will see on the screen. Now, in contrast to flipping, reverse flipping is a process of shifting a company's headquarters back to India after initially locating to an overseas jurisdiction. Now, this trend is gaining momentum as India emerges as a more attractive base for businesses due to various economic and policy reforms. There are several examples of reverse flipping and advantages to it, which Manish will take you all through.
So exactly almost opposite of what I said a few minutes back are the reasons necessary for companies to reverse flip today. I think first and foremost, so that you all have a context, right? Some of the examples. So we have situations right now that we have a complete flips that have already happened. or reverse flips that have already happened, and in some cases there are some ongoing flips. So examples of complete flips are companies like PhonePe, which necessarily completed the entire reverse flip mechanism in October of 22, and let's say a company like Grow, which completed the reverse flip, I think somewhere in 2024. So these are examples of companies who have already flipped, and then there is an ongoing trend of many companies which are in the process of currently flipping, which are some of them are like Pine Labs, Zepto, Flipkart, Razorpay, CreditBee, Meesho. Some of these companies are already ongoing in terms of their flipping exercise, and some of the key drivers to the flipping piece, I can tell you from as a banker, one of the biggest drivers commercially is a favorable IPO climate in India. Now, almost opposite of what I mentioned, decade forward, that is today, India has a very, very deep capital market pool. We have very sophisticated investors who can understand fintech, who can understand the kind of consumer base, the market that India operates, and are ready to put in chunks of capital at reasonably good valuations, and essentially driven by exits of private equity funds who have invested in these entities. So a favorable IPO climate in India, which is driving higher valuations than globally, is one of the biggest reasons for flipping. Together with that, I think a trend which is also catching up is the deepening of the investor base, right? Along with the IPO, you have a very, very diversified global pool of capital available, which is investing across all categories of funds, whether it is sovereign funds, whether it is growth funds, whether it is hedge funds, all investing in India at this point in time in these things, and also aiding this trend is a lot of governmental assistance, right? In terms of once a company reverse flips, the startup ecosystem in India is way more vibrant than it was a decade back. Whether it is the National Atal Mission, whether it is the initiative for developing and harnessing of innovations, whether it is the entire regulatory framework of the GIFT City, wherein you can access pools of capital globally, staying in India even after flipping. So these are some of the additional governmental considerations. And last but not the least, at least from a tax consideration perspective, India has seen a reduction in corporate tax rate from 30% to 25%, abolition of dividend distribution tax, where the burden of dividends is shifted to shareholders and not to the company, streamlining of foreign portfolio investments, tax holidays for startups, exemption from MAT, and the entire advanced pricing agreements regime in the transfer pricing regime. All of this also is leading to trends of reverse flipping, right? So that's one. I think a couple of points also can be discussed by Kosha related to the other trends that she's seeing. Kosha, you're on mute.
My bad. Let me move on to liberalization of regulatory norms. Now, to add to what Manish's reasons already
You need
were.
to stay in the slide. I think we are on the traditional flipping side, right? So
Yeah.
Yeah.
So India has now made significant efforts to create a very business-friendly environment. And this has invited companies to strongly consider returning to India and has catalyzed a surge in reverse flipping. And let me give you a few examples of the reforms. One such example is the FDI relaxation. Over the last 5 years, the government has liberalized FDI policies across several critical sectors. In insurance, the automatic route limit rose from 49 to 74 in 2021. And in telecom, the FDI cap has increased from 49 to 100%. Apart from that, touching up on a few amendments to the Companies Act, recent changes have simplified the compliance processes, especially for startups and small companies. These amendments have also decriminalized offenses, reducing the compliance burdens on companies, promoters, and its directors. Compliance procedures have also been simplified. For example, in small companies, you're no longer required to prepare cash flow statements. Board meetings for small companies have been reduced to twice a year. And you also need a shorter annual return form in Form MGT 7A. Apart from Companies Act, one more major change is the increase in the insolvency thresholds under IBC, which is now increased from 1 lakh to 1 crore rupees. This really shields businesses from unnecessary insolvency litigation and helps in creating a more stable environment. Finally, we're seeing a huge geopolitical and manufacturing shift. Global tensions, particularly involving China, have led companies to diversify their supply chains. In the background of this evolving landscape, India has emerged as a key player by leveraging initiatives like what Manish mentioned, Make in India, to position itself as a preferred destination for manufacturing and operational hubs. Global tech giants like Apple, Samsung, Dell have all shifted their manufacturing to India. And basis public news, we also know that Tesla is actively evaluating India as a potential base. Now that we've finished the concepts of reverse flipping and also the reasons for it, let's talk about, while there are several methods to do a reverse flipping, we're going to talk in this presentation about the two most popular and efficient ways that a company can relocate its headquarters back to India. And one of them is an inbound merger, especially considering the recent amendments under Rule 25A of the Companies Act, which allows mergers to be undertaken through a fast track route. Now, what is an inbound merger? It basically involves a merger of an overseas holding company into its Indian sub. And as a part of this process, the resultant company, which is the Indian company, and it will help you to look at the diagram here, the Indian company issues its shares to the shareholders of the foreign holding company as a consideration for the merger. Now, while mergers like these were permitted earlier, they required NCLT approval, which was both time consuming as well as costly. The fast track merger route was reserved for mergers between Indian holding companies and their subs, and of course, startups. But now, with this new amendment, the fast track route includes foreign holding companies merging with its Indian subsidiaries, which has also led to a lot of reverse flipping. Now, what is a fast track merger, you may ask, right? A fast track merger is a streamlined process which does not require an approval of the NCLT, which is the National Company Tribunal. Relative to a court-approved merger, a fast-track merger significantly reduces timelines, almost down from 12 to 18 months to 3 to 6 months. Now, while a fast-track merger requires government approval, if the government does not raise any objections for 60 days, then the scheme is deemed to have been approved. Now, in this case, it's a cross-border merger under fast-track route. There are several compliance conditions that have to be noted, and this is a bit legalistic, but bear with me. Now, while the first of these conditions is that companies are required to obtain RBI approval, what's important to note is that if you do comply with the FEMA cross-border regulations, that is basically your pricing norms, entry routes, sectoral caps, and reporting requirements, then you don't need a separate RBI approval and it's deemed to have been gotten. Right? Further, the merger also needs to comply with Section 233 of the Companies Act, which is basically, let me just touch down on certain key aspects. It needs to be approved by 90% of the shareholders. In an inbound merger case that we are referring to, it will be 90% of the shareholders of the overseas holdco, of course. You also need creditors representing 9/10 in value to approve the scheme. Now, the fast-track merger requires approval of the central government. And as I mentioned earlier, if there's no feedback from the central government for the prescribed timeline, then it's a deemed approval. It's deemed approval by the regional director. But they have the ability to raise objections if at all. Now, additionally, if an overseas company is incorporated in a country which shares a land border with India, and I'm talking about this because of the Press Note 3 issue now, which is quite common, a declaration in connection with approvals obtained under foreign exchange framework, along with a copy of the approval, is also required to be filed with the central government. Now, another point to note is that companies have been granted a 2-year transition period to regularize any non-compliances that come across during the merger process. Okay, let me give you an example. Like if the resultant company is not permitted under FEMA to acquire or hold any asset or security in India, it must sell such asset or security within this window of 2 years. Also, any guarantees and borrowings of the transferor foreign company that become the guarantees and borrowings of the Indian resultant company is also required to comply with applicable FEMA regulations after the flip. Now, to summarize in total, this amendment is a welcome change and is in line with the government's attempt to combat regulatory hurdles and create a much more business-friendly environment. Now, by allowing reverse flipping transactions under the fast track route and doing away with the time-consuming process of obtaining approval from the NCLT, this amendment makes inbound mergers a very attractive option for reverse flipping and may also facilitate completion of such transactions in time for the ongoing IPO wave in India. Over to you, Manish, to talk about some of the tax considerations for an inbound merger.
Sure. So, Kosha, as you know, I think this is one amendment for this inbound merger that the industry, the private equity funds, businesses have been waiting for long, and it's an absolute welcome change. And that's why you see such a sea change, right? And one of the biggest considerations when you do this reverse flipping, apart from obviously the regulatory foundation enabling it, is the tax consideration. And I'm happy to state that inbound merger is the most tax efficient structure, right, that you have for the reverse flip. So let me start by saying that the inbound merger, this is an absolutely tax neutral event in an overall scenario, and I'll explain this in parts, right? So first and foremost, the foreign amalgamating entity will be able to claim exemption from capital gains arising out of such transfer under Section 47(6) of the Income Tax Act, subject to obviously this transaction qualifying as an amalgamation under Section 21B of the Income Tax Act, right? And what are the conditions of Section 21B? Pretty straightforward, right? One is all the property and liabilities of the amalgamating companies become the property and the liabilities of the amalgamated company, which is typical of amalgamation, right? And shareholding of minimum 75% of the value of shares in the amalgamating company become shareholders of the amalgamated company. So if we imagine a typical traditional flip structure, almost always you will be able to satisfy the conditions of Section 21B, right? Necessarily meaning that it will be called an amalgamation. And if it is called an amalgamation, then it will be a tax neutral event under Section 47(6), right? Obviously, the definition of transfer includes extinguishment or relinquishment of capital assets, and therefore no tax implication will be there on shareholders of the merging entity, so long as shareholders of the merging entity receive shares in the merged entity, right? And that's carved out in Section 47(7). So assuming that we are satisfying the definitions of amalgamation and those of conditions of Section 47(6) and 47(7), and of course compliance with the pricing guidelines, the entry routes and sectoral caps as per the FDI regulations as narrated by Kosha, we have a situation of a tax neutral inbound merger option for the reverse flip. Yeah.
Thanks, Manish. We'll move on to the next most popular method that we see for reverse flip structures, which is our share swap. Might be important for you to look at the screen because this is a bit more complicated to explain, but let me try my best. Now, typically in a swap, the shareholders of the overseas holding company transfer their shares to a newly formed Indian company, and in exchange, the new Indian company will issue shares to those shareholders. Accordingly, the overseas holding company then undergoes a voluntary liquidation, and its assets are distributed to its shareholders. Now, in a typical share swap, once the transaction is completed, the shareholders of the foreign company come to hold shares of the operating Indian company indirectly, as you can see in the second diagram, as the Indian company becomes a wholly owned subsidiary of the newly formed Indian entity, in which the shareholders now hold a direct stake. Now, relative to an inbound merger, a share swap is much quicker and may only take a few weeks, though the duration may vary depending on the legal requirements of the host jurisdiction. However, it can lead to heavy tax implications, which Manish will explain in some time. Now, it is important to note that under FEMA, a share swap is permitted only for Indian companies engaged in sectors falling under the automatic route. Now, both the inbound and outbound legs of the transaction have to be FEMA compliant. So let me explain that. The issuance of shares by the new Indian company to the non-resident shareholders of the holdco is required to comply with the non-debt instrument rules, which includes your sectoral caps, pricing guidelines, and rules applicable to deferred consideration. Now, also the share purchase by the new India company from the overseas holdco shareholders is also required to comply with ODI regime, which includes your total financial commitment limits, prohibited sectors, and your round-tripping restrictions. Now, another favorable development in this regard has been the changes introduced to the NDI rules effective from August 2024. Now, prior to the 2024 amendment, while the ODI rules permitted share swaps for overseas investments, the NDI rules did not expressly permit Indian companies to issue shares to non-residents in exchange for shares of foreign companies. This limitation meant that FDI leg of any share swap still required an RBI approval, adding to the procedural complexity. Now, following the 2024 amendment, Indian companies now have express permission to issue shares to non-residents. in consideration of shares of the foreign company, as is in the structure we're talking about, eliminating the need for an RBI approval for the FDR leg completely. Now, accordingly, the Indian for exchange control regime is fairly conducive to share swaps. Over to you, Manish, to talk about the more critical tax implications on this structure,
Correct. So,
which
Kosha,
can ultimately
yeah.
drive decision. Yeah.
Yes. I think you will agree, Kosha, that one of the
Yeah.
biggest hurdles for this method is the tax considerations, right? Because
That's
fundamentally what happens is that as per explanation to Section 911 of the Income Tax Act, shares of a company which are incorporated outside India will be deemed to be situated in India if the shares are deriving directly or indirectly substantial value from the assets located in India. And essentially, most of the traditionally flipped structures fall in that category. Therefore, when we reverse flip by way of swap of shares, the indirect transfer tax provisions must be evaluated from the perspective of extinguishment of shares of the shareholders of the foreign company. And essentially, because you are in a cross-border situation, most of these reverse flip structures will also attract indirect transfer provisions under the capital gains sections, and the DTAA provisions for the jurisdictions from where we are actually reverse flipping will come into picture. And of recent, most of the DTAA provisions have carved out some of the other capital gains tax implications in the hands of the foreign shareholder, right? And when we do this, the capital gains tax in the hands of the foreign shareholder would be a delta between the valuation of the shares of the Indian entity at the time of the reverse flip and the cost of the acquisition of the shares of the foreign company at the time that they were originally acquired. Therefore, it's not that it's never possible to be doing it. It depends upon largely three things, right? One is what is the jurisdiction where you're doing this reverse flip from? What is the DDAA provisions? When were these shares acquired? What are the provisions that are applicable under the DTAA? And essentially, what is the delta between the valuation of the shares of the Indian company at the time of flip and at the time of the acquisition? So these are the core aspects of the tax considerations. There are also some other softer aspects, right? So, for example, a lot of foreign shareholders that we talk to are always wary of what kind of tax assessment risks are they open to when they actually end up doing this share swap, etc. What is the and probably also imagine that some of these startups and fintechs would have also some accumulated losses that they would have accumulated over time in their initial funding stages. So one has to evaluate the impact of the potential lapse of these accumulated losses that are available to foreign companies and to the Indian companies prior to internalization. And last but not the least, the tax implication in the hands of the foreign shareholder at the time of eventual exit from the Indian entity after the reverse flip. I mean, either they're thinking of an exit in the form of from an IPO standpoint or a strategic sale in the market. So tax implications at that time also will have to be taken into consideration because the first event is becoming taxable. So obviously, this method is way more tax inefficient compared to the inbound merger route. But it's not that companies are not taking this because every situation has a different connotation to it and a context to it. So depending on the business considerations, the cost of acquisitions, the fair value of the shares, the DTAA, I think companies end up selecting one or the other of the two options, right? And just to proceed, I think I'll just also give two examples, right? I think which can give context to our listeners here. By the way, we've started to get a lot of questions. We'll try and address some of these questions as we go on. So between two examples I wanted to take, that is Grow and PhonePe. I just mentioned both of these completed their flips totally. So Grow was the case that Kosha dealt first, right? That is the inbound merger structure, very tax efficient, and no taxes were paid, etc., etc. So this company got domiciled or re-domiciled from the US back to India under this structure, whereas PhonePe took a different route, right? It took a share swap route and used the DTAA in Singapore that was there, and so you have both examples, and the one of the reasons for these choices are basically because of the speed. As Kosha had mentioned, the share swap is obviously faster than the inbound merger route. So depending on the cost of the commercial considerations for capital gains tax, the speed of execution, and the regulatory highlights that the regulatory considerations, one does a choice between one of these two options, right? Yeah.
Yeah. So now that we have understood the reasons for reverse flipping and the types of reverse flipping structures, Kosha, can you help us with what would be the
Yeah,
key considerations for reverse flipping?
sure. Let me start with some of the key considerations now that you've heard both aspects of what you should consider while reverse flipping. It's essential, of course, to select an appropriate structure that is not only commercially beneficial, but is also compliant with legal, regulatory, and tax regimes in the relevant jurisdictions of the inbound mergers and the structures. Now, depending on the industry of the entity, also, there are several approvals that may be required. Let me give you an instance. RBI requires prior approval for any change in control for, say, an NBFC or a housing finance company. So those are all things we must consider when we are planning a reverse flip. Manish will dive a little more into tax implications, but I also want to mention that another relevant aspect is ESOPs, right? In case of employees engaged with offshore entities prior to internalization who decide to continue their employment with the Indian domiciled entity, any stock options that were granted to such employees will need to be structured as per the requirements of the Indian laws. And fresh stock options will need to be issued by the Indian company instead. Now, in that case, you'll have to consider the compliance under Companies Act, where a minimum cliff of 1 year from grant of ESOP before vesting is required. Now, in case of a fresh issue, this has to be adhered to, and we need to align with the employees to that respect. Manish, over to you to talk about some of the tax implications.
Yes, so I think we've covered it in detail, but just to
Yeah.
summarize, I think a trade-off between speed for execution and having the structure in place versus the tax neutrality of the inbound merger or the share swap. Right? That's the key consideration that one needs to assess. I think what I've seen is that where the cost of acquisition of the shares and the fair value of the underlying Indian shares is not too much. People prefer the share swap option because commercially it is not that tax inefficient. Plus, it gives them the flexibility of speed and documentation to be done largely internally. So that's one thing. The second thing is most of the, at least 70 to 80% of the reverse flip discussions that we've done are related to the company potential resulting Indian company going for an IPO. Right? And therefore, feasibility of the IPO, timing, valuation, and exit in the IPO. So a lot of the private equity funds, a lot of investors in the IPO process are doing an OFS, which means an offer for sale. When they do an offer for sale, essentially, if they're classified as promoters, there's some portion of their shareholding which is locked in, and some portion of the shareholding which gets allowed to be sold as a part of the IPO proceeds. Right. So once you do the reverse flip, then a lot of companies also evaluate how close are they from that potential IPO exit option that they are envisaging. And the timing of that also is a big determinant in deciding when to do reverse flip and which structure to kind of take it up, right? So these are a couple of these commercial considerations which are very vital, which I've seen in these discussions.
Yeah. So I think to sum up, what we see is reverse flipping isn't just a trend, it's actually a response to India's transformation into a thriving, business-friendly destination. And with regulatory reforms and as Manish mentioned, a favorable IPO climate and increasing investor trust, India is quickly positioning itself to becoming a promising hub for businesses to grow. Now, what I think this webinar emphasizes is that prior to proceeding with the flip, it's very essential to conduct a thorough diligence to address the legal considerations upfront. Now, these key aspects of this diligence will include compliance with regulatory requirements, such as adhering to valuation guidelines under FEMA. And if there are any convertible instruments, then it becomes important to structure the transaction in a manner that preserves their terms. Now, certain startups face restrictions on granting of ESOPs to promoters and employees holding ESOPs in overseas holdcos, may also face issues due to India's regulatory requirement of 1 year gap. These are all things that we should consider before we discuss and decide on a reverse flipping method.
Yes, and I think just to sum it up, I think Kosha has covered everything well. I think typically we've seen CFOs, CXOs, tax teams of companies, and legal councils of companies, essentially preparing a comprehensive checklist coming to tax advisors and legal advisors like us to actually deep dive into all possible permutations and combinations before we actually select the entire structure. So there's a lot of work that is done upfront, right? And things get complicated with when shares are issued over time in the holdco, right? Because then tax implications also have to be taken accordingly. So all in all, I think a lot of companies are going through it, and I'm seeing another trend, Kosha, is that once we are seeing all the big names, right, already go for the reverse flip, whether it is the phone pays of the world, the grows of the
Yeah.
world, the Meeshos of the
Dance.
world. But
Great.
I'm seeing also a lot of second category companies who are not the big names, but doing wonderful business by themselves, also thinking of the reverse flip option as a option for getting more into the Indian market, attracting capital, whether it is private or strategic in nature. So this is now no longer a trend which is only applicable to the big companies. It's also being applicable to a lot of companies who are kind of
Mid-level
getting.
analysts.
Yes,
True.
yes.
True. I'm not touching on CCI and regulatory approvals because I see there are some questions on that. So, Megha, do you
Yes.
want to move on to the Q&As?
Yes.
Yeah. Thank you, Manish and Kosha, for the insightful discussion. Now I'll move on to the Q&As which has come. The first question that has come is, do we need the CCI approval for reverse flipping the entities? Kosha, over
Yeah.
to you.
So as I did touch upon earlier, but it's also important when you are considering reverse flip to assess whether a CCI needs to be notified. This, of course, depends on various thresholds have been met under the CCI Competition Act 2022. And if those thresholds are met, then you will require to make a filing.
There's one more question is whether it is a state central government or it is an MCA approval.
Sorry?
There's one question which they have said, what is the state, whether it is state approval, central government approval,
It's a
or
CG approval, right? Like what I mentioned in the inbound merge you're talking about, right?
right.
Yeah.
Also, do we need any valuation to be done, or are there any issues
Yeah.
when?
I think we mentioned that under FEMA, you need to comply with pricing guidelines. That's correct, Megha. I think
Okay.
there's a question on Press Note 3 also. I'll touch upon that. Press Note 3 approval would also be required for investors that are linked to land border countries who are allotted shares of the resultant Indian company. And also, as previously noted, if a merger involves an Indian company that is incorporated in one of these countries sharing land borders with India, then a declaration in form CA 16 is also required, along with copies of previous Press Note 3 approvals obtained, if at all.
Okay, there's one more question. I think we answered what is the minimum vesting period for ESOP. The minimum vesting period is 1 year. Okay, and there is one more question which says that what is a tax intensive, whether it is practical to go for a share swap. I think even that was been touched upon by Manish.
Yeah, so I'll tell you, I'll just add there. So typically, it is intensive only when the delta between the fair value of the Indian shares and the cost of acquisition of the original cost of acquisition of the foreign shares is a lot, right? Not always the delta is high, and then the tax intensity will not be that much. So the trade-off is between the quantum of tax, or the larger the delta, it will be a disincentive. But if the delta is not too big, then the share swap is way quicker than obviously the inbound merger route. So that's how it is.
Okay. So there's one more question. Interesting it is. They are saying that the reverse flipping is the new trend, but there's another trend that is the citizenships are moving out of India. What do you think? What is
Okay,
your
so
perspective on
so
that?
I'll just go for it. So basically, actually, there are two very, very different things. A reverse flip structure is basically for business considerations, market considerations, exit considerations for investors and businesses to come into India to take charge of the Indian market, or to use the Indian market to exit your shareholders or create value. It's essentially business. For people taking citizenship outside India, they're very, very different considerations. It can be because of assets being held outside India, because of wealth being accumulated outside India. It could be because of business considerations where business are being set up outside India. So it's a very, very different parallel thought process. Both of them, I have no technically there's no relationship between both of them.
Okay. I think we have answered most of the questions which has come so far. So thank you, Kosha, once again, and Manish for your valuable insight and thought-provoking discussion today.
I can only tell all our attendees that this is not a one size fit for all kind of a situation. So
That's correct.
obviously, if you are thinking and you have questions, we are happy to as InCorp and Trilegal combined, we are happy to take questions, help you through this process, discuss various considerations that may be at the top of your head, and essentially, InCorp helps with the entire tax piece, tax evaluation, etc. And
Yeah.
we partner with Trilegal for all the legal aspects, for the considerations, for the cross-border stuff. So we, in combination, help clients to help and progress on the reverse flipped decisions, etc. So please feel free to reach out to us. I think our contacts are there, and we will be more than happy to take questions and help you and guide through this process. Thank you very much.
Thanks, everyone. It was really nice. And thank you for taking the time out to hear us on this presentation. And as Manish said, please feel free to reach out to us. Our contact details are on the screen. If you have any other specific questions, if you need help in structuring or actually going through, we both InCorp and Trilegal are happy to help you.
I just got one question. I could see some open questions. I'll just answer that one. How efficient is MCA route in case of cross-border? So because it is at the regional directors level, obviously there is always a basic education to be done, but they are very um, uh, uh, they're open to this process, especially now that we have some precedents here.
Okay.
Yeah.
So thank you for the wonderful audience in making this session very lively and interactive. So
Thank
if you do have more questions, please reach out on the contact details that has been shared. And also don't miss out on the next session in this series on In.Talks. Please do follow us on the LinkedIn. Please stay updated and on the upcoming webinars that we'll be having. Thank you.
Thanks,
Thank you so
everyone.
much. Thank you, Kosha. Thank you so much. Thank you, Megha.
Thanks, Manish. Thanks, Megha.
See you.